Get ready for the dictation on the count of 3, 2, 1, start. A similar view was taken by this court in the state of Kerala versus Ramaswamy Iyer and Sons. This was a case under the Travancore Cochin General Sales Tax Act 1958. Here also the decision turned on the definition of turnover, which is similar to the definition of the term in the Madras General Sales Tax Act 1959. The position was further explained in Delhi Cloth and General Mills Limited versus Commissioner of Sales Tax Indore, which was a case under the Madhya Pradesh General Sales Tax Act 1958. The relevant provisions of this act appear to be similar to those of the Madras General Sales Tax Act 1959, stating that the liability to pay tax under the act is that of the dealer. H.J. speaking for the court said that the act did not confer any statutory power on the dealer to collect sales tax as such from any class of buyers. Unless the price of an article is controlled, it is always open to the buyer and the seller to agree upon the price to be payable. While doing so, it is open to the dealer to include in the price the tax payable by him to the government. If he does so, he cannot be said to be collecting the tax payable by him from his buyers. The levy and collection of tax is regulated by law and not by contract. So long as there is no law empowering the dealer to collect tax from his buyer or seller, there is no legal basis for saying that the dealer is entitled to collect the tax payable by him from his buyer or seller. Whatever collection that may be made by the dealer from his customers, same can only be considered as valuable consideration for the goods sold. It is clear from Section 21A of the Madras Prohibition Act 1937 that the sales tax which the section requires the seller of foreign liquor to collect from the purchaser is a tax on the purchaser and not on the seller. This is what makes the authorities on which counsel for the appellants relied inapplicable to the cases before us. Under Section 21A, the tax payable is on the price of the liquor and that tax is to be paid by the purchaser. The seller is required to collect the tax from the purchaser which he has to pay over to the government. Section 21A makes the seller a collector of tax for the government and the amount collected by him as tax under this section cannot therefore be a part of his turnover. Under the Madras General Sales Tax Act 1959, the dealer has no statutory duty to collect the sales tax payable by him from his customer, and when the dealer passes on to the customer the amount of tax which the former is liable to pay, the said amount does not cease to be the price for the goods, although the price is expressed as X plus purchase tax. But the amounts collected by the assessees concerned in these appeals under a statutory obligation cannot be a part of their taxable turnover under the Madras General Sales Tax Act 1959. The appeals are dismissed with costs 1 hearing fee. Appeals dismissed.